All right. Ms. Hancock?
Roll now. Chris Kraft.
Here.
Klein Lauterbach. John Hudson.
Here.
Hugh Harvey.
Here.
Dina McCullough. Here. Sidney Chisholm. And Veronica Thornton. Mr. Read the notice of the meeting.
All right, go right ahead.
This is something we start.
Saw that on the minutes, I saw it on the minutes in April. Go ahead.
Yeah. Okay, this meeting's date, time, and location have been posted on the Tennessee Private Probation Service website, included as part of this year's meeting calendar. The agenda for this month's meeting has been posted on the council's website since May. And this meeting has been noticed on the Tennessee.gov website since June the 4th.
Here, motion to adopt the agenda.
So moved.
Second?
Second.
All in favor, say aye.
Aye.
All right, motion carries. Fifth,
So moved.
is there a adopted? And we have, next on the Department of Correction staff members. We appreciate y'all being here today to help us understand what's going on. Have your little name tags, but if you would introduce yourselves for the record, please.
My name is Bobby Strader. I'm Assistant Commissioner of Supervision.
I'm Debbie Inglis, General Counsel for the department.
I'm Lisa Helton, the
And council members, if you'll turn to tab 3 in your books, there's just some information to help you with the discussion today. I've provided for you a copy of that law change in 2012 where private probation agency requirements can supervise Class C felons. And there's also, I provided a list of our licensees who are currently listed on our website that hold an active license, and it gives you their original date of license issuance. And I've also given you local government tort liability issues in where the requirement for the misdemeanor companies' insurance requirement that comes from the Tort Liability Act. So that's a few things that might help you in the discussion.
Wanted to hear what's going on with all this. If any of you care to ask, I've heard from Memphis, a lot of the probation companies, we have a lot of them in Memphis, are always wondering, who's going to get these jobs and how much they're going to be paid and when this is going to happen. And I said, well, the law gives you the right to contract with them, but doesn't say that you have to. And we had several private companies that were handling e-felons because the judge appointed them, and we've gradually gotten the judges to stop doing that because that was illegal. And then attorneys started to say, well, they can do it now. This is an e-felony, and we've had to tell all the judges, no, that's not for you. It's for the Department of Correction. So do you have a time schedule of when y'all are going to draw up a contract or put out bids or however y'all are going to handle this?
We don't actually have a timetable yet, but we do have a working group that is discussing various issues preliminary to an RFP. Working group involves people from the field as well as central office folk. We have issued a request for information to get some input from these private companies on various issues, drafting the RFP, and we've received those responses. We had responses from five companies. And so we are meeting on the 18th, again, to go over those responses, see if we need additional information, or are we in a position to go ahead and begin drafting that RFP? There are some issues that we and I think the payment is one of those issues. The department, if the department is supervising a Class C felon, they're going to pay a $15 supervision. Also pay the criminal injuries compensation fund. I know the legislation allows us to go up to $60 for that supervision. We're concerned about the disparity in find someone to a private probation company, and because of that assignment, they end up paying $60 a month as opposed to $50. That's something we're going to have to give some thought to, and hopefully come up with something.
Several of our probation companies thought that they would just enter into a contract.
I think what we were contemplating, because the statute does give the authority to charge a supervision fee, is that supervision fee would be their payment.
Basically, the private company would collect that rather than, okay. All right. One of the other concerns that some of our companies had, all I can speak of is Memphis, unfortunately, which is probably not an average probation company. Department of Correction, rather than giving them people on probation and e-felonies, they would give them like determinate release people. And usually, like in Shelby County, if you get 2 years or less and the judge turns them down for probation because they're unsuitable, they go out to our local workhouse and then they get determinate released, even though they're totally unsuited for probation. And then they would get those people who would immediately violate because that's one of the reasons we didn't put on probation. Anyway, and they were concerned with, well, what kind of people would we get? Would the department just give us folks that are in a lot of trouble so that they won't have to handle them? Those are some fears that they were expressing, and I kind of told them I would let y'all know that they just have no idea. I think some of them said, well, we're not going to apply until it's other people do it and we figure out what's in everybody's mind, because I know Governor Haslam wanted to reorganize government, but they're thinking, well, they just want to save money and they're going to save it by trying to get us. Same way that 2 years ago the Supreme Court put out bids for representation of indigents, and they were just going to hire some lawyers and give them so much a month to represent so many people as a money saver. And it scared all the attorneys, one, because they wouldn't get appointments, and two, there would be these new lawyers that don't know what they're doing, that would contract because they have no practice and they just got out of law school. And but nobody really knew. Everybody was just floating the idea, and nobody knew what's going on. So I think there's a lot of uncertainty there about applying for this program, not knowing what you're going to require of them.
I know that we haven't specifically talked about the issue of determinate release. I'm glad you brought that up, and we will consider that. I think our plan would be, in assigning people to private probation, would be objective criteria. It wouldn't be, there might be some exclusions, but otherwise it would be sort of just a look at the draw.
Right.
We wouldn't try to discriminate against or send the worst to the other.
Well, because the statute now says basically if it's an e-felony and it's a property crime, you pretty much have to put them on probation. And so they don't really know what kind of folks they're going to get. Put it that way. It's like Forrest Gump. You just don't know what you're going to get.
We'll definitely take a look at the determinate release and see if we need to exclude them.
I'm not speaking for them necessarily, but I'm just letting you know what the concerns are if they're there.
Our next meeting, we'll look at what our next steps are, but we are making progress. Of course, this past year, we've been involved in this transition of moving acclimated to that, and this is, on our agenda now. It's unclear from the legislation what was contemplated, and we'd certainly be interested in what role you would want to play. I don't think the statute requires anything other than the taking.
Well, right now, I mean, for them to exist, they apply to us and we approve them, and I'm assuming that you have no say in which company you choose or whether or not you approve them. License away or suspended them, you would have to figure out what you're going to do with all your probation or parolees in that case.
I would just like to state real quickly that this would be a registration program and not a licensing program. And so we, in our discussions that we had yesterday with General Counsel, we believe that the board council would not have the ability to enforce any sort of punishment or anything.
I don't want to tell the Department of Correction what to do for sure.
I think we just strictly can provide the approval process for them, and then at that point, it's up to the Department of Corrections to determine whether or not they're going to contract with them or not. So that's kind of where we see the council's point of view at this point.
One thing I didn't understand is we already applied the approval process to have a company exist. I didn't know if we would need to also approve them to be used by the Department of Correction. I mean, the way I read the statute, it really doesn't say that we have any say in it, other than that they can't do business with a company that's not an approved probation company. Is that right? Or
right? I think they would have to meet the minimum requirements to be a misdemeanor probation company, and then also have to provide additional evidence that's set out in the statute to prove that they're fit to also oversee Class E felons as well, and then we can approve them after that. So I think our thoughts would be that we're just here to basically application and then make sure that they're fit to Class E felons, and then at that point the Department of Corrections takes it.
one other question some of the judges had was, if we have someone who a warrant for violation is filed, and they come in, and let's say it's a lot of times what the judges will do on the e-felonies is their probation of 1 year or 2 years is fixing to expire. They will violate their probation and then reinstate their probation and put them back on probation for 3 years. Put a person on probation with a private probation company. So if we violated their probation, we could not put them back on probation. And only the Department of Correction can do that. So our question was, if we violate their probation and then reinstate it to give them more time to pay restitution or to get their GED or whatever they have to do, we would have to use the state probation, I guess. And we weren't really sure what we should do with that.
Yeah, I think in that situation, they would come to state probation, but then we would be able to reassign them back to the company at that point.
So you think that even if they're not sentenced to the Department of Correction, you could still do that?
Wouldn't all of them be sentenced, like the sentence would be suspended to Department of Correction, and then the Department of Correction is contracting where they're supervised? Is that correct?
Right, right.
So on a reinstatement, would they I think they would be reinstated to Department of Correction, and then Department of Correction would determine who.
Wouldn't specify that they're reinstated to the private company. You would just which would be-
probation.
Mhm. And
All
then
right.
we would assign them if we thought it appropriate. We'd send them back.
Originally, judges envisioned someone incarcerated, and then they would be paroled out to the private probation company. For instance, not just put on probation, but paroled out. Nobody really, everybody's saying, what are they going to do, and how are they going to handle it, and what's legal. And
Parolees will not be a part of this. Well, it has to be a suspended probation sentence to
Right,
be
we
eligible for
aren't-
private.
We're not looking to put parolees on
Well, that's
this.
the question of what determinate release people are. We don't really know if they're parolees or probationers.
We look at it as being on probation. In fact, we call it determinate release probation. The board has no say in releasing them, so
Put them on probation, we deny their probation, and then we get a violation on them 4 weeks later because they went out there in a week, they got probation, and then
About, and I'm not sure the class of felony, violation of sex offender registry, that's a Class E, isn't it?
it's a felony, but it only carries a fine. And we have people that are arrested for not having a sex offender ID. For court, and we have to arrest them, and they're in jail a couple of months before they say there's no jail time, and so they're just. Since it's a fine, they can't be placed on probation.
But we have violation of sex offender.
Now, if you violate the
Offenders-
sex offender registry,
Right.
it's a minimum 90 days, but it's an e-felony, but it's a minimum 90 days they have to serve, and then they can get probation.
That's it's a Class
It's an
E.
E-felony.
So is that, and my reason for raising that concern is because private probation companies don't do sex offender registration. We do it in state probation and parole. We are responsible for the registration of sex offenders. And so I think that could get into a problem if they were, I think that's a class of people that the department would want to look at maybe excluding.
Yeah, I think that's a good point. We looked at the whole process of a person getting on probation and looking to see at what point we would turn someone over to private probation, that maybe we would do the initial set them up in Thomas and things like that, and get that all done before they go to the private probation company. But we'll look at the registration that might be an exclusion.
Probation companies think y'all are going to keep the easy ones and then give them the sex offenders and the repeat violators and stuff like that. That's what they're afraid of because they're looking out for themselves, So.
I don't think that's our plan. But
I know that, but I mean,
I can see that.
until they see it in writing,
Exactly.
that's why you're not getting many people applies because they don't know what your plan is. They just figure it's the government and they're saving money on them. So I'm not expressing that view, of course.
Well, and like Judge Kraft, I'm just speaking from my experience and where I work, but one of the things that we noticed that there are more probation violations from private companies than from state level supervision. And I think part of that is because they quickly violate for financial reasons. And I think another reason for that is because they're for-profit business. And if they can violate an offender and then get them extended we see that a lot, that they get a lot of extensions. And so I'm concerned, and this may not be the platform to be, I might just on a personal level with my employer, discussed that, but it's a concern that there would be people who would normally be on state probation going to a private company and being subjected to more onerous vision, but
As I could give you an example, I've told this a couple of times at these meetings, but y'all weren't here, so I'm going to say it again. Had a doctor, he was I want to say brain surgeon, a neuro, whatever they're called, and he made like $200,000 a year, and he was arrested for a second DUI, and the private probation company filed a violation. He'd been 10 months into a 1129 probation for a DUI. And he testified at the violation hearing that he thought it was wrong that he be violated because he'd paid his non-reporting fee. And what happened was they said it's a $50 fine if you don't report. And so he gave him $600 when he started probation and said, I don't want to see you people again. And they said, okay. And then he picked up his second DUI 10 months into it, and then they had to file the violation. And there were a lot of people that were doing this that we didn't know anything about. And then I would have people who had bad drug screens for 3 or 4 times, and they would say nothing to me, and then about 8 months into it, they would stop paying their fee, and then they file a violation and allege the prior drug screens plus non-payment of the fee. So there's a concern there that if they're paying, they're not going to violate them. If they're not paying, then they are. And the government, employees of the government really, and I know we all care that the government collects its money, but as employees of the government, they're not personally affected if somebody doesn't pay their fee. And so they're impartial to a certain extent. Not that we don't care, but we're impartial. Private companies are different, and so that's why I've always opposed and spoken out against private companies having felons, just because there's more potential for private corruption there. But the legislature has done what they've done, and that's our concern, is that they'll be taken advantage of by the companies.
That's definitely one of our concerns. Another concern is charges for various programs and groups and things like that act on over and above the supervision fee, and so we hope to address that in the contracts.
We have a price list when they apply of what they're going to charge. That's why that form is so.
I really do hate to see just the luck of the draw on whether you get private or state probation making such a difference in the supervision and the economic that might have. And, you know, we want these folks to be successful, and so we don't want a lot of extra charges on them that's going to keep them from being successful.
I think we're just trying, probably from our things we've heard and experienced, just throwing some thoughts out to you when you're doing your investigating of it, because I know that I hear complaints because we do dual supervision a lot of times, people that are on private probation as well as felony probation, that they are charged monthly drug screen fees regardless if they're drug screened. And so, yeah, there seem to be a lot of additional fees tacked on sometimes with the private. Diversions would probably be a wonderful group of people to look at going to private. You know, they tend to be more successful and have the potential to do well and maybe not encounter some of the things that the ne'er-do-wells.
and also restitution as well. You know, someone's vandalism over $500, Class E felony, and they've basically brick through their girlfriend's, or she has keyed and thrown a brick through the window of his other girlfriend's car, and they owe $800, and they're making minimum wage, and they make the payment, but they get violated because those payments were applied to for the probation fee, where if they're on state probation, a lot of times if they're poor, the probation officer will call me and I'll waive the supervision fee, which is bad for the taxpayers, but it's to help someone who legitimately cannot make the money, and somebody's on diversion, and we cannot extend their diversion. So the private companies will not do that because they have to make a living.
There are times I just tell a private probation company, you're going to waive the fees, and
Well, in diversion, the judge is the only one that can waive the fee. We have a procedure in place for probation fees to waive, but diversions, the court is the only one that can waive that. And you're right, I don't think you'll be approached to do that.
Yeah, the private probation company they'll just eat the fee if they wanted to do that.
And one dilemma with the 1 and 2 year sentences of restitution is the court clerks take their money first. So, their sentence may be 3/4 of the way over before they satisfied their court costs and fines, and they've never started on restitution.
not only do they take theirs first, the oldest case, the payment's going to be for like the oldest case, and we've got
A lot of the judges, and like in Shelby County, we don't do this, but a lot of the judges, the probation company collects the court costs as well for the clerk. And in Memphis, we don't do that, and so somebody can actually still owe court costs, and we're not going to violate their probation if they can't pay the cost. But the probation company, a lot of times, collects those costs for and there are some companies, I was talking to Senior Judge Ash, used to be judge in Rutherford County, where the clerk was collecting, the company was collecting the costs, even though they weren't placed on probation. There were some people they were just collecting the costs for to get the business. And so the counties all do it really differently, unfortunately.
It looks like it's probably going to be a little bit longer before.
There are so many issues that we are running into. Our primary concern is, effective supervision and public safety. So we want to make sure that we have control over this. We have talked about maybe just doing a couple of pilot programs, maybe a rural and an urban area, and see what we learn from it before we go out too broadly.
A mechanism to take them back from probation, from private probation to state supervision?
We will address that in the RFP. I think, the legislation lets us assign them, and I think we can reassign back to us, and we will ensure in those contracts.
One other ugly topic is, really y'all were supposed to kind of talk to us, but we're talking to you. I apologize for that.
Well, this is extremely helpful, though.
Well, the ugly subject of politics. We had a probation company which I had to immediately shut down because they were writing people and saying, we know the Republican judges, and so if you use us, you'll have better chance of getting probation with Judge so-and-so and so-and-so and so-and-so. They're actually writing people letters to the lawyers, writing the lawyers letters. And so they lasted 2 more days, and they were shut down because it took me 2 days to find out about that. There's a concern among companies, well, do we need to hire some Democrats? Do we need to hire some Republicans? Who do we need to influence? Who's going to be the person to decide which companies do what? And so you may find yourselves in a situation where, like in a county with more than one company, and there are several now, there'll be some companies that are, quote, connected or not connected, and whether they're not are or not, when there's a probation violation, there's going to be allegations they're violating me because I'm this political party, or this person, we'll have complaints to us, this person is getting all the inmates because, the probationers, because they're in connection with this governor or that governor. And so I've done, because we have judges accused of, also on the board, I'm the chair of the Board of Judicial Conduct. We have judges accused of getting kickbacks from private companies to send in business, is that the attorney decides what company they're going to use, and I have no say in that. Some of the judges do that, some don't. But there's talk. Well, there's this one general sessions judge that only uses one company. We'll wonder why that is. And, and all this rumors go. Especially the offenders don't really want to blame themselves for their situation, so it's always somebody else that had an in or something like that. And so you'll have to figure out a way, I think, to assign companies, not just people, but companies, so that there's no appearance of impropriety. I don't know if you want to use a rotating system or what you want to use. There's got to be some kind of a way. I don't know if you're going to have companies bid or which companies you're going to choose. There may be, there are some companies that I won't use, but I say on the record I'm not using them because the last time we violated a guy on a drug test, they said they couldn't show that it was his drug test. They weren't keeping good records, and so I'm never using your company again, and I say that to them in court on the record. But there's got to be some way to put all that out there, otherwise there'll be a lot of allegations about abuse because of political reasons, because of the state government situation rather than the local county government.
I think that's a good point.
Unfortunately, it is. I hate to say that it is, but people say that kind of stuff. Else you want to ask us?
No, I would like to say that we might like the opportunity to come back as we get farther along in this process and run some things by.
Didn't you have anything you want to bring up for discussion while they're here?
No, I think they pretty much covered everything. We just wanted to give them an opportunity to come here and present their side and what they think their expectations are and that sort of thing. But I think we'll continue to work closely with them as this develops. Sure to invite them back to future. Let you know about the any updates or anything of that nature.
Anytime you want to come, we're here 4 times a year. So
I will bring up one thing. If we have a complaint filed against a company, and if there is action taken, be it just a fine or a notice or whatever, if it's a company that DOC is contracting with, I would think you would want to know there were.
Absolutely.
I guess that, down the road, a mechanism.
when do the complaints become public record? Right, like right now, you never tell us the name of the company for obvious reasons until we resolve it, usually. But when someone files a complaint, that's not public, is it, until you've investigated it?
I believe the complaint file, as far as the board goes, or the council goes, that's public record, because we have people that request access to those records from time to time. But
we agreed at one point that we didn't want to know where the company was or what the name of it, because some of us may know the people involved in it.
right, and we work very hard to keep them anonymous before we present them to the council, and then so there isn't any thoughts of impropriety or anything of that nature. So.
Never known anybody we're dealing with, so couldn't recognize.
I knew one time just because I was in the county, and so I recused myself from that. So all those records are there for y'all to look over whenever you want to, and be glad to work. All right, I think we're on. Thank you all very much for coming. On your legal report, Mr. McDonald.
That concludes my legal report this time.
All right, thank you. You're not working as hard at all. Ms. Hancock?
Yes, if you'll turn to tab 2, this is my budget report for you, and this goes through, as you know, we're nearing the fiscal year end. June 30th is our year-end report. In a month behind, and what you see here in the right-hand column is just through April 30th of this year. Showing you where we are through 4/30 compared to where we were for the final closeouts in 11 and 11 and 12. So far we've received $200 in application fees. We've received quarterly provider fees, $3,300 in renewal fees, $461 in miscellaneous.
Fiscal year, previous fiscal year is 126. Am I over?
Well, there's still two.
We had 2 months. That'd be 1,000 a month, and you had 20. That'd be
Through May 30th and then through June 30th, Dave.
Right, I'm thinking calendar year. Yeah, okay, I'm good.
All right, the next page over is your expenditure report showing where your fees are going. Again, it's a comparison, and it's through April 30th. Top in the right-hand column, you'll see that a total of $9,729 was payroll expenditures. Coming down the column again, with other expenditures for travel, communication, office supplies, state professional services, $9,366 added to the $97,000. Now, one thing they have not put on this report so far year-to-date is your rental expenses. If you remember back in November, I sent all of you an email telling you they have now started charging rent to office space at $850 a month. And that began in May of 2012. So they will add that year-end fiscal report for in that column. So, total of $19,095 so far this year, with the net revenue reported of $103,364. When I get the final year-end report, there will with cost backs and all of the other expenses that you typically see. That's the only report I have for you today. We have no complaints to compare, so if we had any this time last year, it would have been 1 or 2.
That's a good thing. We're doing our job. Anything else to come before the committee? Do I hear a motion to adjourn?
So move.
second.
All in favor, say aye.
Aye.
Let's vote with our feet. Thank you very much.
Thank you.